Okay, this is the People versus Mark Nozel. Can I get your appearance, counsel?
Yes, Neely Bryant for the city of Taylor.
Mr. Nozel, can you tell me your name, please?
Yes, Mark Nozel.
All right, so there was a default judgment entered against Mr. Nozel. He appeared in court and indicated he didn't think he should have to pay for the ticket. I told him that there was an appropriate form to file if he wanted to set aside a default judgment. He filed that paperwork with the court shortly thereafter, and I did grant his motion, so the default has been set aside. And Ms. Zelnick?
Yes, so we're going to adjourn this for a formal hearing. I did speak with the city prosecutor, Matthew Zick, for Taylor on this case. He just told me to advise the court that the charge for the formal hearing at the next court date will be amended to 16 to 20 over.
All right, Mr. Nozel, do you understand that?
That it's going to be renegotiated.
Well, no, it's not renegotiated, sir. The ticket was originally written as a double parking, the default ticket. But I assume, I'm going to look at the ticket. It states on the ticket, sir, which I can only assume you have a copy of. Double parking 165, 0 points. On driving record 53 and a 35 at 621 feet in a construction zone. So they're moving to amend the ticket back to the non-reduced charge of the speeding in a construction zone. Is it 16 to 20 over, or is it, hold on. And that would have been 53 and a 35. So yeah, so the allegation is going to be that you were doing 16 to 20 over in a construction zone. That's a 4-point ticket. So they're going to move to amend to that.
Well, that's what Ms. Zelnick informed me that I needed to do in order to negotiate my position on the ticket. Since I was given the impression it was negotiable when he negotiated double parking, but if I'm misinformed, then I'll just go from there.
I told the defendant that he could pay the double parking. That was all that was being offered, or we have to set it for a formal hearing. And I advised him as to the charge being amended at the formal hearing.
So it was already, I mean, the prosecutor's position is that it was already reduced down when it was written as a double parking instead of the 15 to 20 over. So if they're having a formal hearing, the prosecutor is stating that it's going to be amended to the 16 to 20 over for the formal hearing.
So if that means that I'm going to get to talk to the officer and explain my position on it, and if he could reduce it to a double parking based on my good record, accelerating out into a construction zone where there's no speed limit posted, that possibly I could have been reduced to like a parking ticket or failure with my seatbelt.
Well, I mean, they already gave you the double parking.
Yeah, but I would want to reduce it to something less than that.
But there's really not much less than that.
Parking ticket?
For a city ticket, I mean, a double parking is a 0-point infraction. I don't know what else they would reduce. I mean, that's not my place. That's the prosecutor and the officer's place. But
Well,
generally,
I could be wrong, but I would think a parking ticket is much more reduced than a double parking ticket.
well, we don't, I mean, there has to be an ordinance that complies, sir, and I'm not aware of one.
An ordinance that complies to what?
I mean, there has to be a city ordinance for that type of case. So
Versus-
for them to
I'm
reduce
not
it to a parking, there would have to be a parking ordinance. There's a double parking ordinance.
Oh, they don't have parking ordinances?
Not to my knowledge.
Do they have failure to wear a seatbelt?
I mean,
The prosecution is just going to offer the reduced charge, which is what we told the defendant, that it would be the double parking, and we discussed that that was reduced at the time. So we are offering the double parking, and if you want to pay that, we have no problem with that. The default was set aside and that was granted, but that's all that we are offering at this time is the double parking.
So when's the court date?
You'll get it in the mail, sir.
Thank you.
So to be amended to 16 to 20 over, it'll be set for a formal hearing and you'll get notice of that date in the mail.
Will I be offered legal?
It's a civil infraction, sir. You're
Okay.
not given
Well, I'm
counsel
confused
for that.
because they sent that
No,
to me in the mail and I had a right to do
The
that. So I'm
only
just-
way you get counsel and have a constitutional right to counsel is generally if it's a misdemeanor or there's a possibility of jail time. And there's no possibility of jail time on a civil infraction, so you wouldn't be entitled to a free attorney or but you can retain attorney, certainly.
Does the court offer me one?
I mean, I don't have an attorney for you.
The
I
city
can't get. What are you confused about, Mr. Nozel? I just
Okay.
explained to
Let me
you.
just.
You do not have a constitutional right to an attorney because this is a civil infraction and there is no possibility of jail time.
Well, I'm trying to clear up your confusion by getting my paperwork out here. I had an offer to retain an attorney, so I'm confused. Would you understand why I would be confused when the offer was made to me to call one?
I don't have anything about offering you to retain an attorney.
I got a letter to call an attorney from the city of Taylor that I would have the right to an attorney. That's the confusion. Can I be any more clear?
Sir, I don't know who you think you're talking to, but I'm not going to have you snapping at me and could you be any more clear? I've indicated to you, it is a civil infraction. You do not have a constitutional right to an appointed attorney. I don't know what
With all due
paperwork you
respect,
received
I'm
from
not
the city of
snapping.
Taylor or from the
With-
prosecutor in the city of Taylor, but you received nothing from the court offering you a free attorney, as you refer to them as, because you don't have a constitutional right to one. There's no possibility of jail time.
With all due respect, I wasn't snapping, but it sure sounds like you're snapping.
All right, we're done here today. You'll get notice of the date in the mail. If you want to retain an attorney, you're free to do so, Mr. Nozel.
Thank you. Have a nice day.
Ms. Douglas, you are the witness with respect to a person named Zanae Shaw.
Yes, ma'am.
All right, Ms. Shaw has not appeared for court. This is the first scheduling of the pretrial conference. So, well, it may not be because it's a 2019 case. It's the first.
I remember which one she is. Oh, I'm sorry.
You have forgot.
No, I know the situation and scenario. So I was confused at why I was coming to court today because the other three people we already went to trial for them and they were on probation. But Ms. Shaw is the person that didn't show up.
Okay.
She's the one that did the most damage. She busted.
Okay,
my
hold on.
car.
Don't say nothing else. No,
I'm so sorry.
No, because you got caught up and I just don't want to hear any of the other facts in case Ms. Shaw shows up next time and they ask for a bench trial. That's the only
Yes,
thing I stopped you. But yes, so now that I'm looking at it, Ms. Shaw is defendant number 3. Well, so now that I'm also looking at it and she's defendant number 3, Ms. Rudder, can you check and see if Ms. Shaw has capias before? It sounds like she's capias before if the other 2 people. Mr. Myers, stabilize your device. You're making me dizzy. Let's see if Miss Ms. Douglas, don't laugh at me. Let's see, I'm sure Ms. Shaw capious before. If she's capious before, I'm gonna go ahead and capious her again, and I'm gonna set a higher bond.
I have a warrant request entered 9/9/2019.
Is that the only one? All right, okay, so I'm not gonna issue the warrant today. However, I am going to adjourn the case for Ms. Shaw. I will adjourn the case. Ms. Douglas, you appear today. You don't have to appear on this adjourn date, but you can if you want to know firsthand what happened. But I'm going to adjourn, give Ms. Shaw one more opportunity to show up for court before I issue a higher bond on her case. So I'm going to
Yes, ma'am.
set the matter for, let's adjourn Ms. Shaw to what month are we in? June. This is the end of June. Oh, I gave myself 1, 2, 3, 4, 5, 6 sentencings on one day. Ain't that crazy?
It is.
I know. That's something. I don't know why I did that to myself. All right, let's adjourn to August 10th at 8:34. Ms. Rudder, 8:34. 8:34. That lets me know that if Ms. Shaw fails to appear, I'm going to issue her, I'm going to issue a capias, and her bond is going to be $5,000 cash surety plus a GPS tether. 8:34. 8:34.
Yes, ma'am.
Judge, may I think I remember this case, and I think we went to trial, and I think I already represented.
Ms. Stevenson, are you telling me something that Ms. Shaw showed up? Because otherwise, why do I need to know this?
I'm asking that counsel be appointed for Ms. Shaw.
Ms. Douglas, she's saying stuff that don't have nothing to do with you.
That's
Yes,
and don't have nothing to do with what we doing today. So anyway, you're all set, Ms. Douglas.
yes, ma'am. Thank you,
Have
Your
a
Honor.
great day. Stay safe, okay?
Yes, ma'am.
All right. Ms. Stevenson, you could just send an email about that. You could tell the clerk you need counsel.
okay.
All right.
Because since we called it, I'm
I
like,
didn't call it though, because I didn't.
oh, okay.
I
I
didn't call it.
apologize for that. Then
Mr.
I
Myers, I
apologize
need
for
you
that.
to stabilize your device. I need you to stop rubbing your eyes, your head. We are in court. We're in court. We are in court. We're in court. Okay, you're not listening to me, Mr. Myers. If you keep on moving that device around, I'm going to discontinue your case, and you're going to have to come in person. All right, I need everyone to sit up straight and be stationary as if you are standing at the podium. We're standing at the podium. That's what's going on right now. Everyone is standing where Miss Ritter is. Everyone is right there lined up. Okay. This is case number 224430101. The people of the state of Michigan versus Frankie Michael Myers. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for an arraignment. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, and I also have the complainant witness present via Zoom this morning. Mr. Fay, unmute yourself and state your name for the court, please.
Unmute yourself, sir. Unmute.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Frankie Myers. Mr. Myers, sir, please unmute and tell the judge your full name.
Frankie Myers.
Is a date set for an arraignment. Mr. Myers is gonna have to come to court for his pretrial. Ms. Stevenson, how are you proceeding?
Mr. Myers here for arraignment stands mute, waives the reading of the information, asks that a plea of not guilty be entered on his behalf. We're asking for pretrial conference, Your Honor. I don't know of any capious history in this matter. No objection to no contact with the complainant.
Court will enter a not guilty plea, set the matter for pretrial conference, September 27th at 8:29. Strike that. That should be 8:25. I'm getting mixed up on my times today. At 8:25. Discovery should be submitted by August 25th. Ms. Ritter asked to bond.
Judge, we have no objections to a personal bond in this matter. We're just asking for no contact between Mr. Meyer and Mr. Bryant.
Court is going to set bond in the amount of $2,000 personal bond. No contact between the defendant and the complaining witness. Anything further?
No, thank you, Judge.
It's pretrial. Today is the day set for an arraignment, Ms. Stevenson.
No, I don't have anything further. Thank you, Your Honor.
All right, then we're all set. Gentlemen, have a great day. Stay safe. This is case number 1-844-374-01. The people of the state of Michigan versus Priscilla James. Defendant is charged with one count of failing to stop at a collision damage accident. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Priscilla James. Ms. James, ma'am, please unmute and tell the judge your full name.
My name is Miss Priscilla James.
Ma'am, state your legal name for the court.
Priscilla James.
Thank you. Today is the date set for an arraignment on a bench warrant. Ms. James was scheduled for trial back in 2019, where she failed to appear. And then she came out of warrant status in 2021. And then she was scheduled for an arraignment on a bench warrant and she failed to appear. And then she came out of warrant status again at the end of 2022. She was scheduled for a final pretrial conference and she failed to appear. And now she's back again in 2023. Ms. Stevenson?
Thank you, Your Honor. We first want to acknowledge receipt of discovery, and Ms. James will continue her plea of not guilty. Your Honor, we're asking that this matter be finally scheduled for final pretrial conference. And we are asking that the bond, which is posted, be continued. Your Honor, Ms. James.
How much she posts? She KPS 5 times, 4 times. This is a mess. This is a mess.
The last bond, I think, was $100, 10%, which and I have to confirm that. I think that's, and I know that Ms. James did post that bond. Ms. James, by way of explanation, not excuse, has been in and out of the hospital relative to
every time
chronic
since
health.
2019. Every time she get a court date, she go to the hospital, and then as soon as she get out of the hospital, she don't show back up to court. She don't say, "Oh, I missed court again being in the hospital. Let me hurry up and get down there.
Since I make that representation only with regard to the KPS at February 15th, 2023, I do not have a fresh explanation for prior KPS. I think I probably offered them last time. Ms. James has been advised that if she does continue to miss court, her freedom is on the line. There's no tether at this point. Ms. James, we've explained to her that that is inevitable should she continue to miss court, and we would ask that bond be continued.
It's inevitable today. Miss Ritter, we're not going to keep looking for Miss James. We're not going to keep looking for Miss James, charged with failing to stop at the collision damage accident. We're not going to keep looking for Miss James. She clearly she didn't stop at the accident according to the people, allegedly. And then it seemed to me like she would just want to hurry up and get it over with. Who wants to have this hanging over their head for 3 and 4 years? I'm not going to keep doing this. Miss Ritter?
Judge, so as the court sees, there is a bit of a KP's history in this matter. Just reminding the court that this is a case from 2018. This is already putting people in jeopardy as securing their witnesses for this case, Judge. So I'm going to ask the court to actually issue a higher bond in this matter, not a personal bond, just so that we can come to a lawful conclusion with this case.
Oh, I didn't even mean to send that to everybody. Oh, well, I guess I did though.
Looking at my case notes too, Judge, and one of the prior explanations we've offered for failure to appear is that Ms. James suffered at least one stroke.
You know, Judge King had a stroke while he was at work on the bench. And the next week he showed up for work.
Judge King is Superman, Judge.
Oh, well, Miss James better drink some juice or something and become Superwoman, because she keep on missing court. And we're not going to keep on doing this. And so I'm sitting here contemplating if I'm going to go ahead and put her on a tether now. That's why I was just ignoring, you know, I wasn't silent or just, I was thinking. I'm thinking, am I going to make her come down here and come down to the tether unit and get a tether now? And so for me to say that, we know it's something, because I don't like tethers on misdemeanor cases. But this particular case is a case ripe for a tether, because we keep giving her a personal bond. She keeps coming and then not coming back. Then we give her a low bond. She come and then don't come back. So she only posted $10 to get this court date. That's that. I went to the fast food the other day. I was so irritated. My little sandwich or something, the little thing cost $12. I said, you can't even, you got to just eat bread and peanut butter and jelly sandwiches. Can't even eat no eggs and stuff. $10 ain't nothing. That's nothing. She won't miss that $10. But if she got that tether on and some house arrest or curfew, I bet you she'll come to court, because she's trying to get that tether off. So let me just be clear, Miss James, I'm fed up. In case you didn't know, on behalf of the court system, I'm fed up with you not coming to court. This is this go round right here. This is your last opportunity to handle this case outside in the free world. If you fail to appear for this next court date that I'm going to give you, your bond is going to be $5,000 cash surety plus a GPS house arrest tether. So if you post the $5,000, then you're gonna go home or somewhere and be on a tether. Yeah, that's how I feel too. Taken aback by the fact that you have capious 4 times on this misdemeanor case. That's how I feel. The court is going to leave the bond the way it is. I'm going to set the matter for another. Court is going to set the matter for another final pretrial conference. September the 7th. At 9:04. Bond will continue with no driving without a valid license. If the defendant fails to appear on September the 7th, 2023, her bond will be $5,000, cash surety plus a house arrest, GPS tether. Anything further?
Thank you, Judge.
Nothing on behalf of Ms. James. Thank you very much, Your Honor.
You're very welcome, ma'am. You have a great day and stay safe.
Thank you, Your Honor.
You're welcome.